When I started my legal career in 1990, emails were still in their infancy. Communication mainly happened through letters, fax, and phone calls. If a document had to be sent to a client, it would be painstakingly photocopied and physically mailed to the location. With some luck, the client would receive the draft in a few days. If any of us need to send a document today, it would take a few clicks in less than 5 minutes. Unlike today's generation, however, I didn't have the privilege of growing up with computers, the internet, and emails. I had to learn how to use these technologies on the job. From sending my first email in 1996, 6 years after my career began, to now dealing with hundreds of emails a day. This has been a long journey. You may wonder why I'm bringing this up. It's to remind you of the importance that emails have in a corporate setting. Lawyers often issue advice worth crores of rupees through a simple email. Given the importance of emails, I felt that it is crucial to focus on certain fundamentals and unlearning some of the lessons you think you already know. First, try to be brief and precise. Every lawyer receives an incredible number of emails. What this means is that unless a message is short and easy to read, it can be archived. Brief and concise messages are usually read immediately. Keeping it short enhances both the delivery and effectiveness of your message. Then come holding responses. Holding responses are a simple but underrated tool. For those unfamiliar with the term, a holding response is something you send out acknowledging you received an email. Such an email also typically provides a timeline for a response. For instance, if a client reaches out for advice, responding immediately, even if it is just to acknowledge the email, thank them for it and say that you will respond within, say, 24 hours, can make a fantastic impression. Always include a meaningful subject line. Include a subject line message which connects the email to a specific matter. For example, if you are corresponding with someone regarding a deal called Project Apple, make sure the subject line of your email contains Project Apple to allow the parties to have context. It's also important to update the subject line as time progresses, as well as the focus of the conversation evolves. Be careful when you use reply all. It seems extremely obvious, but ensure that you check every email recipient to make sure you want that person to receive a copy of your email. In a worst-case scenario, you could also cause yourself or your clients to lose opportunities, money, and quite possibly business relations and friendships. Always stop and think. An incorrect choice of words or an incorrect recipient can cause a world of hurt. It is therefore important to reread your email before you hit send. I say this again. Rereading emails is one practice I cannot stress on enough. An embarrassing grammatical error, poor language, or even a rash decision can just be prevented by reading an emails multiple times. Think, then send. Times where only a call will do. There are many times when you need to drop the email. In my experience, I have seen numerous instances where an email does not reflect what is actually happening. Reaching out to opposing counsel through a quick phone call can often result in transactions being a lot more efficient. Try not to hide behind an email. Do not write anything in an email that you won't speak in person. Emails can be very easy to hide behind. If I've written a forceful email, I read them again and again to make sure I really want to send them. More often than not, those drafted emails end up in the trash box. And you cannot imagine how relieved I have been in all those instances of not having sent that email. If you follow these simple rules, you will find your email messages are getting read sooner, they are more efficient, more effective, and they result in no embarrassment or regret later.
In the fast-paced world of corporate law, tomorrow's legal leaders need to be more than just traditional expertise. Introducing the LLM in Corporate and Financial Law, a groundbreaking program brought to you by Jindal Global Law School in partnership with upGrad. Designed for the legal professionals of tomorrow, this innovative blended learning program combines academic rigor with real-world application. Don't miss out. Click the link in the description to elevate your career with the LLM in corporate and financial law.
Let's understand the best practices of drafting an email through an example. In this case study, we are advising a hypothetical client on the validity of non-compete clauses in India. Hi Melissa. Notice the use of hi. It reflects the nature of the relationship with the client. Dear may be relevant where there's a long-term relationship. Formal terms like respected and Mr., Miss are usually used when there's a substantial age difference or a degree of formality between the two. We understand that ABC Inc., ABC defined. The definition of ABC is very relevant because the word ABC is going to be used several times in this document. Using defined terms not just creates consistency, but also brevity. Wants to incorporate a robust non-compete clause in its employment contracts. This clause will prevent employees from starting a business similar to that of ABC for a period of 1 year post their term of employment with ABC. Here we lay the background before giving the advice. In India, non-compete clauses are governed by Section 27 of the Indian Contract Act. Again, Section 27 is defined. It states, every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. The law is quoted here because it is central to the advice. But quoting may not be necessary in all cases. An agreement in restraint of trade is one in which a party agrees with another party to restrict his liberty in the future to carry on a trade, business, or profession in such a manner as he chooses. Non-compete clauses have been regarded by courts in India as restrictive clauses which undermine a party's freedom to engage in trade. A literal interpretation of Section 27 invalidates all non-compete covenants, irrespective of their reasonableness or consideration paid for such covenants. As you can see, the language here is simple and clear, such that it is understandable even to a layman. As a general rule, post-employment non-compete obligations are not enforceable in India. However, such clauses are included in Indian employment contracts more for moral suasion purposes. ABC can, however, impose a non-compete restraint on employees of ABC during the course of their employment. This, you will notice, is a positive messaging. Please let us know if you would like us to assist with drafting such a clause. This is an example of being proactive. Warm regards. One of the most common issues with legal writing is that it tends to be verbose. There's a tendency to pen down everything the lawyer knows about the topic. It almost appears as if the lawyer is rewriting the question based on his or her knowledge on the subject. But that's not what the client wants. All they need is a clear and concise answer to the question that they have asked. Therefore, after you've prepared the first draft, spend some time removing anything that doesn't support the main argument. The client cares about actionable advice, not legal theory. Another issue that I come across frequently is writing in passive voice. For instance, instead of saying the Supreme Court held that, which is an active voice, lawyers will write, it was held by the Supreme Court that. The latter just makes it so difficult to read. Let's also talk about bullets. In professional writing, bullet points allow you to highlight key terms and draw them to the reader's attention. Instead of writing a lengthy paragraph, which appears like a wall of text, bullets can improve the readability of a document. Linked to this is the idea of using short sentences. The point you are making may get lost if the sentence is too long. Hence, while writing, consider splitting up wordy language. Full stops, not commas, are the way to go. There's a tendency to think that lawyers need to write in a manner that's unnaturally formal. This means using words like shall, hereinafter, and furthermore. I don't think any of us use these words while talking. Then why do we use them while writing? A sentence like Acme International shall comply with these provisions may be rewritten as Acme International must comply with these provisions. Write as you would talk. That's the thumb rule. Remember, you're writing to be understood. It isn't about sounding smart or flaunting your legal knowledge. A person reading what you've written should be able to grasp it quickly and act upon it. Filter out anything that distracts from this objective. I leave you with the advice of Scott Adams, creator of the popular comic strip Dilbert. He writes, "Business writing is about clarity and persuasion. The main technique is keeping things simple. Simple writing is persuasive. A good argument in 5 sentences will sway more people than a brilliant argument in 100 sentences. Don't fight it."